my name is Liza Vinderi. I am from batch 18A. This is because chain of custody is an issue will always be raised during a criminal trial. At the conclusion of a trial, this is also a need properly disposed to property.
Good morning, my name is Priyashini from batch 18A. Today I want to explain about the chain of custody. First is chronological document that records the series of custody, control, transfer, analysis and disposition of physical or electronic evidence. Second is has evidence can be used in court to convert the accused of the crime. It must be handled in very careful manner to prevent tampering or contamination. Third is Evidence Act 1915. Chain of the custody is the witness writing report of all the individuals who maintaining unbroken control over the items of evidence.
Hai, Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Aina Syahira binti Nur Azmi. I am from batch 18A. Today I want to explain about written list. Custody of chain is a written record of all individuals who have ever held or keep evidence. Second, a written list of from whom or where an item evidence is obtained, who collects, who gets handed over to whom. Third, detail about the person collect, maintain, store must be included in the record documentation custody of the change. Okay, next example of physical evidence. There are three examples of physical evidence, which is object, body materials, impressions. Okay, for the object like weapon, tool, firearm, displacer, furniture, bullets, vehicle, cigarettes or cigar butts and others. And then for the body material, which is blood, semen, hair, tissue, urine and others. Last but not least is impressions. Impression which is included by fingerprints, tire tracks, footprint, palm print, tool marks and others. Thank you.
Assalamualaikum. My name is Siti Nur Hasliana binti Muhammad Noor from batch 18A. Today I will talk about custody and maintaining of integrity exhibits. Number one is to prove chain of custody. It is sufficient if those called to give evidence show there was no breaks in the chain of custody. It's like no need to call all officers who handle the evidence. The second is, however, if there is doubt that the exhibit tendered was the exhibit collected of the crime scene, it is essential to prove the chain of custody is unbroken. The third is, however, if the exhibit were dangerous drugs, their movement were viral links. The last but not least, exhibit which require examination by expert, like example, chemistry department, usually sent immediately after it was recovered. That's all from me. Thank you.
Guys, my name is Shreya Velan. I'm from batch 18A, DEM 04188065. So today I'm here to present about chronology of documentation. The preparation of chronology offers you the opportunity of organize your thoughts and present to the concern and logical fashion and provide us with a factual resource to which we can refer throughout the case. We often use the chronology in preparing draft, complaint to be filed with the court, and in a preparing response to question asked by the defendant in a discovery. Please remember that it is important to be as complete as possible, and strong points and weak points to allow us to provide you with the most effective representation possible. Documentation starts from the receiving of a communication calls while sitting in the forensic office, and it is ongoing until the investigation is complete and the case is closed. And the documentation requires investigators to be systematic and organized in their procedure to record and preserve the location and relationship between the physical evidence and the crime scene or the body found. Put everything in order day by day it happened. If you cannot remember the exact date, try to put down month and year. If you are not sure what month something happened, try to identify whether it happened before or after some other incident in the chronology. We prefer to keep the original during the course of litigation, as the court may require the original to be available for review under the certain reason. Please bring in all the documents at your earliest possible where you have tapes, computer disk or other electric data. Please be sure to provide us with a good copy. While retaining one of the records, once the litigation starts, it moves quickly and we will be better able to assist you if we have the documents early. That's all from me. Thank you.
Good morning, Miss. My name is Davaneswari from batch in 18A. Today I'm going to talk about the documentation methods. There are 4 types of documentation methods, which is note taking, still photography, sketching, videotaping, lastly audio taping. Notes, videotaping, audio taping is written records of activities, location of physical evidence, description of people at scene, condition of crime scene, and author's spy findings. Sketches and photography complement each other to depicting the crime scene, victims' injuries properly. One picture is worth 1,000 words. Thirdly, movement and location of evidence. Wherever an item of evidence is found, it has been marked with initial for later identification, but not to damage any of the specific identification characteristics. Finally, personnel and agency involved. Each officer who accepts an item of evidence, signs and dates the evidence back is responsible for maintaining its integrity until it passes along to the next officer through the link in a chain. That's all from me, Miss. Thank you.
Assalamualaikum and selamat sejahtera. My name is Siti Nashafika binti Rusailan. Today, I want to present the importance of chain of custody in the court of law. First, as habis, any document or object produced to and identified in evidence. Second, if the chains of custody remain intact, each witness can testify that the item presented in the courtroom in the item collected at the scene and tested by the lab. Okay, next, chain of custody is important. First, to prevent the change of the original condition. Second, to avoid disturbance by adding, removing, moving, destroying, or contaminating the evidence. Third, that's why it is essential to put on gloves and masks when entering crime room. For the last, proper tagging and labeling of physical evidence is also important to add credibility as well as for easy identification in the future. That's all from me. Thank you.
Okay, next I will introduction about disposal of exhibit. Okay, define of disposal of exhibit is all seized property which is whether tenderer as exhibit or not in the trial must be disposed of. Okay. Okay, next is the cost of their duties. Policemen seize properties. There are three. Okay, first is from a person arrested. Second, which is suspected to have been stolen. Third, under circumstances which create suspicion of the commission of an offence. Thank you. Next, I will pass at my friends.
Hi guys, Hania Larita C. Today I'm going to talk about section in CPC related to disposal of exhibits and property. Number 1 is procedure by police of seizure of property. Number 2 is manner is disposal exhibits. Number 3 is order by the court for disposal of property. Number 4 is disposal of seized articles. Okay, now we see for the procedure by police and seizure for property. Okay, there got three ways. Now we see for the first one, where there is a property seized under section of the CPC, means property seizure seized when a person is arrested. Okay, number 2 is where the property is suspected to have been stolen. Okay, number 3 is where the property is found under circumstances which is great suspicion that offence has been committed. Okay, number 2, manner of disposal of exhibits. Example, the conclusion of any proceeding, the court shall consider in what manner the exhibit shall be disposed of. Okay, the country may make order on how to dispose the exhibits. And if the court makes no orders as to the disposal of the exhibit should be handed off the police officer in charge. Okay, the next is order by the court for disposal of property. Any court may impound, seize and take legal custody of any property or document proceed before it. Okay, during or at the conclusion of the trial, court may make order for the custody or disposal of any property document related to the offense committed by the accused. Okay, another way is the power included the power to make order for the fortune, confiscation, destruction, delivery to any person must be done in the accordance with the law.
Good morning, Miss. My name is Bhuneswari Jeri Kalimutu. I am from batch A. Today, I am going to explain about Section 40A, Disposal of Size Article. PP may be able to quote for the disposal of any article specified in Section 407A2. Sized article that may be disposal under Section 407A in dangerous drugs sized under DDA 1952. Characteristic drug laboratories or premises, valuable goods, cash monies, and video compact disc, optimate disc, film, and other similar devices. Publications, books, and other documents with equipments and machineries, timber and timber products, rice, food, other perishable items. Second thing is Section 4073. When can the article be disposal? The article may be disposal after the following procedure has been followed. An inventory of the article, description making, and other particulars which clearly identify the article has been made by the officer who seized the article and the magistrate judge as certified that the inventory is correct. Second, photographs of the article has been taken in the presence of magistrate or judge. And also, where possible, representative samples of the article has been taken in the prison of magistrate or judge, where the article are video compact disc, optic disc, film or other similar devices. The article has been played for magistrate or judge so as to certain the contents of the article. Before the article were disposal of, the court may be allowed the accused to take photographs of the article. Thank you.
Very good morning to me. I'm Jayashree Dr. Shanmugam from batch 18A. So today I'm going to present about conclusion. So the court in this prudence may keep from discarding a show on the off chance that is considered to have characteristic, chronically or other worth. On account of wrongdoing, the state and the guard will be advised to take the display in the way portrayed previously. On the off chance that the display is not taken, inside the time period indicated in the notification, a show cause hearing is booked to decide why the show was not taken. After hearing the show, the court may arrange the show to be unleaded or discarded in other proper manners. Nothing in this guideline is interpreted to be opposition to the system set out in RSA 595A 6 or other general or uncommon laws administering the protection, removal, seizure or obliteration of particular sorts of property. Thank you.